Welcome to This Explainer. Today, we're jumping straight into the high-stakes world of workplace disputes. We're going to demystify exactly how everyday workers are standing up for their rights, and we'll uncover the specific legal mechanisms that are leading to some truly massive financial settlements. All right, $12 million. Let that staggering number sink in for a second. This represents the massive out-of-court settlement paid to dismissed KIIS-FM radio star Kyle Sandilands by ARN Media back in March 2026. Oh, and on top of that, they paid an additional $1.5 million to support his fledgling media company. Now, you might be wondering, how in the world does a workplace dismissal result in an 8-figure payout? Well, it all comes down to the specific type of legal claim that was filed. The secret behind these massive numbers really lies in the stark contrast between two different legal avenues. You see, a standard unfair dismissal claim is strictly capped by law. There's a ceiling on what you can get. But a general protections claim, which is also known as an adverse action claim, carries absolutely no statutory compensation ceiling. Seriously, the sky is the limit. And because there's no cap, a court can award whatever sum is necessary to make a wronged worker whole again. This isn't just about a few weeks' severance. It can include past economic loss for the wages you missed, future economic loss for the income you're likely to lose going forward, general damages for the distress and humiliation you suffered, and even out-of-pocket stuff, like future medical bills directly linked to the workplace incident. But wait, it doesn't stop there. Employers can also get hit with massive civil penalties on top of that compensation. We're talking up to $18,780 for an individual manager who broke the law, and a whopping $93,900 for the company itself per contravention. And the real kicker? In some cases, courts order these penalties to be paid directly to the wronged employee. Section 1. Identifying adverse action and what breaks the law. So under the Fair Work Act, you're protected if you exercise a workplace right. What does that mean? Basically, if you formally complain about bullying, if you query your pay, or if you request flexible working arrangements, the law literally protects you. You are also protected from discrimination based on personal attributes, things like your race, sex, religion, or union membership. If an employer penalizes you for any of these things, they have taken unlawful adverse action against you. Now, adverse action is an incredibly broad term, and it covers a massive range of hostile conduct. Sure, it includes outright unlawful termination, but it also covers way more subtle behaviors. It could mean getting passed over for a promotion you were totally qualified for. It could be a manager unfairly altering your shifts or cutting your hours. It could be a suspension without pay, or, get this, even just the threat of doing any of those things. Let's move to Section 2. A case study on Hahn versus St. Beasel's Homes from 2025. To really understand how this works in real life, let's trace how things escalated for Wei Hahn, a registered nurse at a Sydney aged care facility. Casey, as she was known, had worked there for over 9 years. Suddenly, her workload spiked, and she felt a clique of her colleagues was being heavily favored for shifts. In August 2019, she gets a warning for allegedly calling a colleague a name. Feeling excluded, Casey submitted formal complaints about workplace bullying and some clinical concerns. Fast forward to December, an incident happens regarding the administration of oxygen to a resident, and by January 2020, her employer used that exact oxygen incident to completely terminate her employment. But Casey didn't just walk away. She fought back with a general protections claim. She argued that she wasn't fired for clinical errors at all. Instead, she claimed it was direct retaliation for making those formal complaints. On top of that, she alleged she was terminated due to racial discrimination, pointing out that management continually favored her Filipino colleagues while dismissing her own concerns because of her Chinese heritage. She also argued she was completely denied procedural fairness during her disciplinary meetings. The federal court ultimately completely agreed with her, leveling some incredibly heavy criticism at the employer. The court found that the aged care facility totally failed to investigate her genuine concerns. They noted that the organization orchestrated a trumped-up attack based on flimsy foundations, essentially turning a blind eye to her legitimate complaints to force her out. So what did this mean financially? The true power of a general protections claim resulted in a life-changing payout for the nurse of over $381,000. Just to break that down, $175,000 for past lost wages, $75,000 for emotional distress, $10,000 for future medical expenses, and $60,000 in civil penalties paid directly to her for the race discrimination and retaliation. Section 3. Seeking workplace justice and the reality of fair work claims. Now, you might be thinking a drawn-out federal court battle sounds absolutely terrifying, but let's take a breath and look at the actual stats. The vast majority of claims never even see the inside of a courtroom. According to Fair Work data, 52% of claims are settled early at the conciliation stage. That means both parties sit down, usually with a mediator, and just negotiate a financial payout. Only a third of cases end up proceeding toward a court certificate. So getting an early settlement often means you get faster resolution and financial closure without ever having to endure a trial. However, if there is one absolutely vital takeaway you get from this explainer, it's this: you have to act incredibly fast. If you are dismissed, the clock immediately starts ticking. You only have a 21-day window to lodge a fair work claim. If you just wait around hoping things will get better or spend a month agonizing over what to do, you risk losing your right to claim any compensation entirely. And honestly, navigating this fast-paced system is exactly where non-lawyer advocacy groups step in. Groups like the Australian Workplace Discrimination Representatives, or AWDR, provide strategic guidance and powerful advocacy for employees. They often operate on a no-win, no-fee basis, helping everyday Australian workers find their voice and bring claims against toxic employers during these really complex disputes. So, as we wrap up, I want to leave you with this question to chew on. If you are suffering in silence at a toxic workplace, or if you faced what you believe to be adverse action, whether you were unfairly targeted, passed over, or unlawfully terminated, isn't it time to stand up for yourself? Are you ready to finally find your voice and demand what's rightfully yours?